scheduled hearing on short notice this morning as we're preparing for pretrial issues at this time. Madam Court Reporter, are you ready? All right, thank you. The state's here represented by prosecutors Rob Wood, Lindsay Blake, Rachel Smith, and Tanya Rawlings. Defendants here present represented by Mr. Archibald and Mr. Thomas. And the court had a few issues to bring the counsel's attention today relating to the commencement of trial and the evidence portion of the trial. So, called this hearing. Apologies for the late start. We had several issues to deal with before we could get the hearing started this morning. Is the state ready to proceed?
Yes, Your Honor.
Thank you, Mr. Wood. Is the defense ready to proceed?
Yes, Your Honor.
All right. Thank you, Mr. Archibald. The issue to court, well, as I get started also, I'll note that there is an administrative order that's been issued in this case governing courtroom conduct that relates to the trial of the proceedings here in Ada County. That was the court's March 7th, 2023 order. Pursuant to the terms of that order, in particular, Part 2B, there is a prohibition against using any electronic devices to record, photograph, or transmit any sounds, images, or video from this courtroom. So please bear in mind those in attendance that order is in effect and no recording, audio, or visual whatsoever is permitted during this proceeding. The matter the court wishes to address with the parties today involves attendance of victims in the case as it relates to also the exclusionary rule. I'll note that under Idaho Rule of Evidence 615, there are provisions for the exclusion of witnesses, and under Rule 615A, states that at a party's request, the court may order witnesses excluded so they cannot hear other witnesses' testimony, or the court may do so on its own. And then it talks about who is exempt from that exclusion. The first thing that I'd like to take out is we are not yet in the case in chief or evidence being presented in the case. However, in order to have that on the record and given the nature of these proceedings, the court does find it necessary under Rule 615A to make an order at this point. So in lieu of waiting for a motion of either party, I do find that it's appropriate and there's good cause to order the exclusion of witnesses under Rule of Evidence 615A. So that relates to the stage of the proceedings where witness testimony is taking place. So that would not include, for example, today's hearing. With that in mind, then, counsel, the court has received a list of those people that are scheduled to be in attendance. And I'll just note there's a few things I want to sort out. And some of that I'll do here on the record in this hearing. And some of these other issues will just be an administrative meeting I'm going to have with counsel as it relates to non-legal issues such as seating arrangements. The legal issue today that the court wants to discuss is who is a statutorily or legally defined victim who would not be subject to the exclusion order that the court just entered. I'll also note that we'll submit a follow-up order under 615A that the court did order exclusion of witnesses in this case, so that's lodged into the record. For counsel's information, we've looked into the definition as it relates to Idaho law, who's a victim under those definitions. It's found in Article 1, Section 22 of the Idaho Constitution. Also, the statute, Idaho Code 1953-06, defines victim. And then the definition's not entirely clear in the statute, so there's a couple of cases that have gone into explain through case law what may be presumed to be a statutorily or legally defined victim. So the cases the court has reviewed is State v. Payne, 146 Idaho 548, 2008 case. There's another case, State versus Shackelford, 155 Idaho, 454, a 2013 case. So, looking at the statute under Idaho Code 5306, it talks about immediate families of homicide victims or immediate families, and that goes on to talk about people that are of a youthful age or with incapacity. So that's where the kind of gray area in the statute would be that I see as immediate families. Looking at those case laws, or cases I've cited then, it discusses in particular defining what that means under 5306. It says, quote, immediate family member means spouse, children, brother, sister, mother, or father. And that definition is reiterated again in the newer case of the Shackelford case, and that was the Payne case I just read about. So, I'll be the first to admit, in this case, I don't necessarily completely understand all the family relations that may be in play here in terms of victims. I'll also note that the statute under 195306-2 indicates that, quote, the victim may exercise any of the rights provided by this section by completing a written request on a form provided by the prosecuting attorney to the clerk of the district court. So I recognize that victims have their status as victims, and while that may be a formality within the statute, what it would do is give the court a helpful guidance as to stating everything believes properly falls within the definition of victim. We've made requests to have those forms submitted, and to my knowledge, those haven't been received yet. So what I'd like to do is just begin by inquiring of the state who you believe will be in attendance as a designated victim that fits within that statutory definition. And that way we can ensure that those that are going to testify that do not fall within the statutory definition of victim don't remain in the courtroom during other testimony. Otherwise, they would likely be prohibited from being allowed to testify if they're going to be called as witnesses. So, Mr. Wood, are you going to be addressing the court this morning on this?
Yes, Your Honor.
All right.
Before I go through that list, I think the victim should also include under 19-5306, subparent 5, that a victim is an individual who suffers direct or threatened physical, financial, or emotional harm as a result of the commission of a crime or juvenile offense. That's the actual definition of a victim. So someone who suffers emotional harm as the result of an offense is a statutory victim. In terms of, is the court wanting me to go down through the state's list? We believe that Kay Woodcock is a statutory victim and Larry Woodcock is a statutory victim. Kay Woodcock is the biological grandmother and I guess now legal aunt of J.J. Vallow. She's also someone who cared for him for, I believe, the first 7 months of his life. Do you want me to limit this to the people who would also be witnesses?
I do. Again, I'm not so interested in giving people specific designations other than to make sure we don't run afoul of
So people who may be witnesses on that list: Kay Woodcock, potentially Larry Woodcock. We had listed Annie Cushing, but that was when it was a death penalty case. She will no longer be a witness. Colby Ryan, who is the brother of J.J. and Tylee. And Summer Shiflett, who is the aunt of J.J. and Tylee. Those are the only individuals on that list who are potential witnesses.
Okay, that's very helpful. This is me going back, and I'll review also the statute you cited. I had reviewed that as well to ensure that apply here. And that was the main concern the court had, was who being testified. Obviously noting that, as I mentioned, the issue could arise if somebody
Your Honor, we have made clear that most of our witnesses were for the penalty phase in a death penalty case. So now that this case has changed to a non-death penalty case, then we intend to call few, if any, witnesses. So looking at the juror questionnaire, where the jurors were informed of who the potential witnesses are, most, if not all, of our witnesses listed in that questionnaire will not be necessary for a trial. If my client is convicted, then they will be potential witnesses for the sentencing conducted by this court. So as the names just read by the state, we believe the only victim under Idaho Code, Idaho criminal rules, we even looked at Black's Law Dictionary to see the definition of a victim or a family member. Our position is that Colby Ryan, as the names were read, Colby Ryan is the only one who qualifies under the statute to remain in the courtroom as a victim. We do not believe that Kay Woodcock, Larry Woodcock, or Summer Shiflett meet that definition. And so if they're intending to be called as witnesses during the trial, we would ask that they be excluded under Idaho Rule of Evidence 615, as the court has indicated. So we don't believe a biological grandma or someone married to a biological grandma fits the definition under our law. We don't think that an aunt meets the definition of a victim under our law. And so that would leave the siblings of Tylee and JJ. The only half-sibling there would be Colby Ryan. The children of Tammy Daybell would be victims, and as far as we know, they do not plan to attend this trial. So any siblings of Tammy Daybell, a spouse of Tammy Daybell, parents of Tylee, JJ, or Tammy, and so an aunt or someone married to an aunt does not fit our Idaho law as a victim. So we would ask to exclude Kay Woodcock, Larry Woodcock, and Summer Shiflett.
All right, thank you, Mr. Archibald. Does the state have a response on that?
Yes, Your Honor. Again, if the court looks at 1953-06, it mentioned subparent 3 earlier about the immediate families. Subparent 3 does not define who a victim is. It just simply says that the provisions of this section apply equally to immediate families of victims. But it's not the definition of the victim. The definition is in 5, subparent A. I would note, even though it's not applicable here, U.S. Code often defines grandparents as immediate family members of victims, specifically for murder, and that's 39 U.S.C. 60911, subparent 2. Oh, 34. I apologize. You know, and this is as the state was looking at this yesterday, I'm going to make a policy argument here, so I want the court to know. I know this isn't necessarily legal, but it's interesting. If we were here today to talk about JJ and his grandparents and lending and banking, they are defined as immediate family members under the Residential Mortgage Practices Act. And again, I know that's not what we're here today to talk about. That's 26-31-303. But yet we're going to sit here and say that a grandparent is not an immediate family member for purposes of a murder of a grandchild. A grandparent who clearly falls under the definition of a victim under subparent 5A of 5306. I would note, based on counsel's comments, although they're not on this list, there is Samantha Williams and Jason Williams, who are sister and brother-in-law of Tammy Daybell, who could potentially be witnesses as well. I wanted to bring that to the court's attention.
What were those names again, Mr. Wood?
Samantha Williams and Jason Williams. I would note, Your Honor, that 5306 itself does not define who the immediate family is, but it does define who a victim is. And someone who has suffered emotional harm is absolutely a victim. And I think especially in a case such as this, to tell a grandparent they're not allowed to watch the trial of the murder of their grandson, someone who was a big part of their life. I think we really are running outside what's intended by this statute and what's intended by the Constitution. And I think legally, absolutely, no question about it, Larry and Kay Woodcock meet the definition under 5A of what a victim is. They have suffered emotional harm. There's no question about that. We often go to the subparent 3 on the immediate family. Again, that does not define who a victim is.
All right, thank you, Mr. Wood.
Your Honor, may I offer some rebuttal?
Yeah, let me make a few comments on that. First, Mr. Archibald, on a few points on that, Mr. Wood. First, the court in no way is indicating that anybody's not going to be allowed to come and watch the trial. The question again is any material witness that may testify, whether they are looking at kind of a prophylactic ruling here to prevent later on if somebody sat through and realized that maybe the victim is testifying. So that's where I'm trying to be careful on the issue. On your other analogies you brought in, I think it is appropriate to look at other statutes. 306 does need some clarification, as those cases have stated. And in fact, in that State versus Payne case, which is a criminal case, they look around at other civil statutes, including they cite to Idaho Code 4113.25, which is a trade practice statute to determine what immediate family member means, because there's a definition in that. So I think the point's well taken that we can look outside the scope of the particular statute for further clarification if it's found elsewhere in the legislature. And so, with those points in mind, Mr. Archibald, is there anything you'd like to say as a sort of
Yes, thank you, Judge. Under our Idaho adoption laws, when a parent terminates their parental rights, that likewise terminates that person's parents' rights. So under Idaho adoption laws, a grandma who has a son terminate their parental rights is no longer a grandma under law. So to call Kay Woodcock a grandma, that may be a name that she gave herself, but since her son terminated his parental rights, she is no longer a grandma by law. And so for the state to say to kick grandma out of the courtroom is outrageous. No one's doing that here. She's not a grandma. She is an aunt, a sister to Charles Vallow. And so the Idaho adoption laws would support our position that no one is kicking a grandma out of the courtroom, because the only grandma would be Lori's parents or Tammy's parents. Certainly, Kay Woodcock and Larry Woodcock, although very fine people, met them. They're very interested in the case. I don't have anything personal against them, but they do not meet the definition under our statute.
All right. Counsel, it's an issue
I may, would it be possible for the states to submit briefing?
If you'd like to do that, we can do that. There's obviously a compressed time frame here, so I would ask if there is any briefing through our time frame here. We could be able to have briefing submitted by the end of the week, Friday.
If we submit a brief, we'll try, we'll have it in by then.
Okay.
The state does have a concern about waiting until the evidence portion of the trial on this. We can represent Kay and Larry Woodcock. They have taken great pains to be here for the entire trial. And while the defense might say she's not a grandma, she is definitely JJ's grandma. And so this is something that I think we need to deal with in as timely manner as possible, because great resources have been expended on their part, great emotional investment. And so I just want to put that out there.
Okay, and I appreciate that, Mr. Wood, and I don't have any intention of obviously waiting any longer than necessary. It is an issue that needs to be determined, and we'll do that in this time.